Good afternoon, everybody. Welcome to Caregiver Resource Center OC October live stream, our monthly live stream to bring you materials, informations that is relevant to caregiving related concerns. And today's webinar, live stream, we have a special guest, and that will talk about a very common topic within caregiving, which is relate to um, legal planning and financial planning. So today we have Mr. Daniel York, an elder law attorney, graciously giving us his time today to do a live Q&A addressing question and concern relating to legal financial planning aspect of caregiving. So hello, Daniel. I want to introduce you, and then if you can share with the audience like briefly your background and what you do, that would be good.
Great. Thank you, Peter. And I want to say first a very deeply felt thank you to the Caregiver Resource Center for making this platform available so that your viewers and listeners can really get some good information on things that are important in planning for care. Um, I really like the fact that you emphasized planning in the beginning because the title of our session is Ask an Elder Law Attorney, but elder law covers a really broad range of issues. The things I like to I like to talk about are preventing problems before they can occur, and also making sure that our loved ones, no matter what the level of their function is, or no matter what their diminishments are, that they can participate in their own planning as long as possible. That's very important to me. So, my background, I've been practicing law as a California attorney for over 36 years. I'm licensed in all the courts of the state of California, as well as the federal district court for the Central District of California. I also do work in the areas of probate law, but mostly I focus my attention on planning. I will tell you that in the first half of my career, I did a fair amount of litigation, quite a lot of litigation, lawsuits in the courts. But I found that planning ahead and building things with my clients was far more satisfying and, in the end, far more productive for them to control not just the here and now, but things that happen in the future. Um, I um, I reach out to and do presentations for groups like the Caregiver Resource Center, mostly because I think the public needs education on the topics we're dealing with.
That's very true, Dan. And for those that, if you missed this live Q&A, then sometime Dan also do an actual legal workshop that is at, at like in details. We talk about at least a 2 hour workshops that provide in depth on the same topic that we're going to do it here. And I believe that this also going to be recorded on our website as well if you missed the whole thing. So don't feel that, again, just I'm saying this so you can kind of look at our events program coming up and then connect with Dan in terms of different way, legal workshop, live Q&A and different things. And of course, you can also contact him for one-on-one consultation as well. So with that, today format is that we're going to have, question coming in from the audience watching us live right now. And then we also have some question that been emailing to us. So I think we will tackle that first, the one that is sending us by email. And then whatever question coming in from the audience live, we will tackle that next. What do you think? Is that a good plan?
That sounds great.
Okay. So let's get started here to save our time and make use of our time here. Then first question. So my parents made my sister and I co-power of attorney. Now we are caring for my mom with mild cognitive impairment, and the sister will not agree with me on anything, not on care, financial decisions, ground rules for adult children living in mom's home. I asked her to go to mediation. She won't. What options do I have as a co-durable power of attorney to make decisions for our parent? on my own without the co-agent?
Yeah, this is a very difficult situation. And before I try and answer this, let me say this. It won't be much comfort to the questioner, but I'll say this for the general audience. In general, if you ever consider making someone either a co-trustee, a co-agent for power of attorney, a co-agent for any of the other documents we commonly use, like the Advanced Healthcare Directive, um, or the will, co-executors, always understand there's always that problem of a deadlock where people can't agree. So the first thing I would ask, if I was looking at the document, is I would ask, is there a built-in required mediation or arbitration clause? Perhaps the attorney thought about this in advance and included something. So you might want to seek legal help to find out how you would utilize that. How would you bring someone at least to the table? Um, if that doesn't work, it may be necessary to bring in the courts. And that's always kind of my last resort because it's time consuming and expensive. And unfortunately, if there's not a mechanism written into the document itself, the courts may not be able to do anything but turn it into a conservatorship. And a conservatorship is a much longer process, very involved, very time consuming, and here in California, quite expensive. And I want to say a word here before we go further. I know the live stream is going out by Facebook and YouTube, I believe. And I want to
Yes.
caution everyone that I'm licensed in California. I'm speaking about California law. So there may be some things that are common to other states, but I can't guarantee that these answers would be comprehensive in your jurisdiction. The other thing to bear in mind is that this is general education. So I'm not going to be able to answer in detail because I don't have access to your documents, for example. But yeah, if there is a mediation or arbitration clause, that would be worth trying to follow up and maybe get some professional help.
Thanks, Dan. And thank you for the clarification that what Dan shared is most likely for the purpose of general education, try to pertaining to the person question, so it won't be as individualized or personalized because obviously he doesn't have access to your case or documents. So thank you for that clarification. Another follow-up question on the same scenario then is, can an elder's estate attorney declare the mom incompetent so that she cannot change her will trust without a doctor declaring her capable to make decisions? What criteria does an attorney use to do this?
Okay, this is a very common concern to begin with. So the first thing that I want to say is you're dealing with a legal term called capacity, legal capacity. Legal capacity can be determined in a number of different ways. So let's take the example of a document like a trust, perhaps, that does not have a definition of how to determine that question of whether the person still has the ability to make decisions on their own. Okay? If there is no definition and no mechanism built into the document itself, unfortunately, things get much more difficult. If you're looking for a court decision on that, then you have to go through court procedures. Normally, these take a long time here in California, particularly here in Orange County and the Southern California counties, because the court calendars are very backed up. The other thing is that typically the court will bring in a qualified physician to do an examination and produce an opinion about whether that person has the ability to provide for their own food, clothing, shelter, and to protect themselves against fraud and undue influence. So the bottom line story about court determination is it's very complicated and difficult. And let me say at this point, we rarely use it, and most estate planning attorneys that I know very rarely use the court process unless it's in conjunction with a full conservatorship. Okay. And that's where the court has oversight of everything, basically financial, caregiving, usually everything. Sometimes they can limit. Let me go to the option, the alternative, which is much simpler. Many trusts, I'm speaking of trust now, so I know that the word will was used, but in most cases, I think what people are talking about are either trusts or powers of attorney. There may be a provision in there, and you'll want to look for it under the heading of capacity or incapacity or competence. These are the common words you'll see in the documents. And then very oftentimes, there will be a mechanism, a way of getting a declaration of incapacity. I want to be very careful about this, okay? Very often people come to me initially and they say, I want to get a declaration of incapacity as fast as possible. Well, to begin with, we don't know if that person is completely incapacitated, having no ability to make any decisions about their care, their medical treatment, where they live, how they spend their money, and so forth. That's a lot to take away from a person. And here in California, we operate under the initial presumption in our courts and in our law system that everybody over the age of 18 is presumed to have the ability to make those decisions, or at least some of those decisions, unless proven otherwise. Okay? So if that person still has some ability to give input and to state preferences and desires and so forth, it would be a shame to throw that into question by getting a letter from a physician too early. Okay? The other thing to know is that there may be adjustments needed in their planning. And we've seen this happen where there's a letter now of incapacity, and it calls into question anything that they might sign, and I mean anything that they might sign thereafter. So that's a very very dangerous thing in some situations. Here's my bottom line. You need to make sure that any attorney that you're consulting gets to see the document that you're referring to, and that they know and get a chance to meet the elder or the person with questioned capacity. Sometimes it's astounding. I will hear that people say, "Oh, my mom or dad have Alzheimer's." Well, Alzheimer's is only a diagnosis. It's not a finding of incapacity. We know that people can have anything from mild cognitive impairment to the early stages of Alzheimer's, mid-Alzheimer's, etc., and still have the ability to decide and give input to many of the things in their lives, as long as they have some support and explanation for their choices. All right? So I want to be careful here. I know as a busy working person, and I meet many adult children that are, they have very full days and they're raising families and everyone's in a hurry. So everybody wants to do things quickly. And you have to understand that sometimes doing things quickly may deny a person their rights, and it may deny them an opportunity to have that kind of input. So I would exercise caution. The two documents where capacity comes into play quite often are powers of attorney for finance and the trust, because these are documents that control money and property, right? There is also the advanced healthcare directive, or any document like a power of attorney for healthcare that also bring in questions of capacity, but that's a slightly different topic in California. The determination about the ability to make informed consent decisions usually lies with the treating physician or the attending physician. So typically, it does not implicate the family members or the attorney, and that's a much easier determination to get to.
Thank you, Dan. So we have a new situation now. My mom has Alzheimer's, moderate to severe stages, and we don't have a power of attorney or advanced healthcare directive or any estate planning documents in place. It's my understanding that getting a conservatorship is difficult, expensive, and also has a very high bar. It's unlikely a doctor would agree that she is completely incapacitated because she is still able to converse, etc. But her short term memory is very bad. As the disease progresses, my mom is speaking mostly Korean and seems to understand more in Korean than in English. So she had four questions for you, Dan. Number one,
Sure.
do attorneys require a capacity letter or can they meet with the person to determine if they have capacity without a doctor's note? If it is possible to find an attorney willing to evaluate the person themselves, how would we find one and how would we address the language issues? Also, what would the attorney ask and how long would the evaluation take?
Okay. These are questions that really are representative of quite a few people that we meet with. All right. So let's talk about the meeting with the attorney for a moment. Because the language preferred by the prospective client, so the person here with Alzheimer's would be regarded as the prospective client to begin with, or we've evaluated their condition and their situation. And let me just say as a footnote here, that is an ethical requirement for attorneys in these situations. It's very important for the attorney, as a matter of ethics, to determine early on who is the client, who is the person that will be making decisions about the planning going forward. So, this is a very important meeting. Let me handle the question of language first. Because this person prefers Korean, I would strongly suggest, and I'll explain why in a moment, but I would strongly suggest that the attorney and the client plan to bring in an impartial translator. The courts use translators in legal situations all the time. And while I know it involves some extra expense, you understand they are impartial, they're objective, and they don't have a point of view on the subjects being discussed. They can also be a little bit more careful about the way they translate legal terms or ideas to that senior. The other thing that I do when I meet in these situations is I try as much as possible to avoid legal jargon or technical terms, and I try and simplify my questions as much as possible. Um, when we talk about capacity, we don't mean that this person has to have a deep and thorough understanding of a very complicated vocabulary. Okay? It's possible to simplify it and break it into bite-sized ideas so you can determine what their preferences are and if they seem to be consistently. So there's a lot of things we'd be talking about. We'd be talking about questions of who do you want to manage your money for you? Who would you like to open your mail? Um, who is it that you would like, if you were not able to make medical decisions or healthcare decisions for you if you can't talk to your doctor or the doctor cannot understand you? So we would try and break it down into smaller bite-sized pieces. It's possible that if this person um, can still read and understand words on paper, that we might want to break it down into a series of very short letters with little spaces to answer those questions. Um, I'm going to go back to what I said before. Um, Very oftentimes, people that are not suffering from this illness get in a hurry because they want to get to the goal as quickly as possible. They have busy lives. But you have to understand that with some afflictions, stroke, Alzheimer's, various dementias, it can take that person a little while to process the information. It's not that they don't understand it, it may be they just need a little bit more patience. Okay. So I wouldn't say there is a set list of questions that I, as the attorney, will ask. I'm going to judge their response, how appropriate it is, how well they seem to remember what we're talking about in the short term. Um, and then I'll have to think about what kinds of documents need to be signed and will they understand the basics of what the impact or the effect of those documents will be. Do they understand who the people are that are going to be receiving things after they pass away? Do they understand the people that will be in charge of various parts of their life, etc.? Let me say this before we get off of this question. I am not a psychologist or a neuropsychologist or physician. I do not pretend to be. If it feels that I am in a gray zone with this person, I might ask the family to talk with that specialist and get their opinion, and maybe even provide copies of some medical reports so that I would have some sense of their ability to understand things. It's a very difficult question, and there are so many different factors that affect it. I know I'm going on here, but I want to help everyone to understand that capacity can be affected by things that vary from the time of the day to when that person last ate a meal to what medication they just took to the people in the room that may irritate or agitate them or the way in which they're being spoken to. There are any number of factors that can affect that person's ability to absorb the information they're being presented with. So even in the law, we understand this, which makes it difficult. Definitely makes it difficult. And on the other hand, there are clear-cut cases where the level of cognition and communication is clearly absent. And then we have to go on to the next step.
Thanks, Dan. So the second question is for attorneys that require a capacity letter and don't want to evaluate capacity on their own, can the attorney provide advice about what can be done to get a capacity letter from a doctor so that we can put a power of attorney in place? We have Kaiser Insurance, Northern California. I'm wondering if they have doctors that specialize in this and whether I can request an appointment with a doctor fluent in Korean for the capacity letter, not her primary care physician, through Kaiser or outside of Kaiser's.
Okay. I want to make sure I understand this question, so I'm gonna drill down just a little bit. I want to make one thing very clear. Um, the only way that a power of attorney for finances can be created is if the person still has capacity. That is the ability to understand what they are signing in an informed way. Okay? Only if that already exists can you then go to the question of the incapacity letter that might be required by the power of attorney. Important to understand, too, that powers of attorney are not all written the same way. Some powers of attorney give the agent immediate power. That is the power right now, as of the moment that the document was set up, that it was signed, to go ahead and act for that person in banking with regard to their finances, their property, and so forth. Okay? Other powers of attorney are different. They come in two different kinds, and that is called a springing power of attorney. The powers are written down. The document has been established, but the trigger mechanism has not been sprung yet. Okay, that's why they call it springing. It may be sprung by an incapacity letter from a doctor or from a combination of a doctor and a spouse or two attorneys. However, that particular power of attorney is set up. That's where the power of the incapacity letter comes into play. But no, make no mistake about it. If there is no power of attorney, if it does not yet exist, and if that person has lost capacity, another person cannot create it for them. Not even the courts can do that. Okay?
Thanks, Dan. Question number 3, does the attorney have advice about preparing to have the person evaluated for capacity?
Well, again, I would go back to something I touched on earlier. I think if you have concerns about how it affects decisions about care, long-term care, and the things, for example, that the Caregiver Resource Center might advise about, and so forth, I would say an early visit to an elder law attorney that deals with planning is very appropriate. Um, I would say, of course, I don't want to interfere with medical care or anything, but I would say even before you go asking for an incapacity letter from the doctor, let's find out first what is in place, how does it read, and what can be done with what you already have. There may be more options there than we know about. And then the attorney can make a judgment about whether meeting with that person, might be very helpful. And you can talk about your other options. We're trying to avoid going through a conservatorship, and most planning attorneys that I know try and avoid that as much as possible. They'll make every reasonable effort to try and find a way forward. But
Thanks, Dan.
people ask about. I think I heard the question about an attorney who would deal with incapacity. I would say that most elder law attorneys, that is attorneys that are advising and serving the community of people above retirement age, um, encounter this a lot. And I would say that most of them have a pretty good background and understanding of incapacity and how it can affect planning.
Thanks, Dan. Last question for this case is, if we have a doctor who determines that my mom doesn't have capacity for the power of attorney, can or should we keep checking with other doctors? I think my mom would do best with a Korean speaking doctor who is also very patient and culturally sensitive. So we may need to have her see a few doctors, but I wonder if that's recommended or seen as a bad sign.
Well, you make an excellent point. I'm speaking to the questioner here. You make an excellent point about the role of language and cultural sensitivity. And by the way, I might add that came up in a professional journal article that I recently read on this. So that is a really good point. I would actually go to that kind of a doctor first and not do it, down the road or as an afterthought. I would do it first. And hopefully that person will be patient and be a good listener and have all of those other elements about cultural sensitivity and language proficiency so that they can get the best read on this person.